I would like to take this opportunity to address some of the myths surrounding the prenuptial agreements. The first myth is that prenuptial agreements are only for the wealthy. Not true. Prenuptial agreements are for people who want to protect assets, no matter how modest. Given the high legal fees and stress involved in a divorce, the frequency with which relationships now end, as well as people's increasing financial sophistication and independence, a prenuptial agreement can benefit just about everyone. The second myth, prenuptial agreements are only useful if your relationship breaks down. This is not necessarily true. Prenuptial agreements can be useful to supplement a carefully thought-out estate plan. A prenup can be especially helpful if you have children from a previous marriage or have family heirlooms that you want to keep in the family. The third myth is that love conquers all, and therefore a prenuptial agreement is unnecessary, even undesirable. Some people may think so. I think it's important for a couple to sit down and discuss their future financial plans as well as expectations for the relationship. This type of discussion should lead to a more solid foundation for the relationship. Is it reasonable to leave things to chance expecting that your love will somehow take care of everything? Myth number 4, prenuptial agreements won't be upheld by the courts. Not true. Although courts occasionally do invalidate prenups, these are normally ones prepared without the assistance of attorneys or the agreement was procured by fraud or coercion. If you have a properly drafted prenuptial agreement which includes full disclosure of your income and assets and the process was free of duress, a court is likely to enforce your prenuptial agreement. Myth number 5, only men want prenuptial agreements. Not true. Prenuptial agreements are a useful way of setting out expectations for the relationship. There's no need for a prenup to be biased in either partner's favor. For instance, a woman may insist that if she's going to stay home and raise children, that her prenuptial agreement include provisions to compensate her for this interruption in her career through spousal support. Also consider that today women are building their own careers and developing assets of their own. Those women have as much incentive as men to enter into a prenup. Myth number 6, prenuptial agreements are expensive. Not compared to the cost of an average wedding or divorce. By comparison, prenuptial agreements are a bargain. The best way to think about it is like buying insurance. It's a small one-time cost for something you never hope to use, but if you ever need it, you'll be glad you have it. 9 important provisions to include in a prenup. First, how to compensate a spouse who gives up a job to stay at home to take care of the children. Second, a sunset clause that modifies the contract if the marriage lasts longer than, say, 20 years. Third, a provision addressing spousal infidelity or abandonment of the relationship. Fourth, language to identify whether particular items of property are considered community property or separate property. Fifth, who will own the marital residence in the event of a divorce. Sixth, language determining responsibility for premarital debts. Seventh, determine alimony obligations. 8, determine which state's law should be used in interpreting the prenup. And 9th, how disputes about the prenup are to be resolved, for instance through mediation or arbitration. Remember, the range of what can be in a prenuptial agreement is flexible. Now let's talk about what can't be in the prenup. There are some strict rules about what cannot be in a prenuptial agreement. In other words, prenuptial agreements have limitations which are imposed by state law. Generally speaking, prenuptial agreements cannot deal with the following issues. First, custody of the children. Second, visitation of the children. Third, child support. Fourth, anything illegal, and that's true in any contract. And fifth, anything that's unconscionable or unfair. Although most states permit prenuptial agreements to deal with alimony, a court is allowed to invalidate the alimony provisions if the judge believes them to be unjust. This will normally occur in long-term marriages if there's a great disparity between spouses' incomes and no or little alimony being paid. You should discuss and set up the informal structure of your prenup before you each hire a lawyer. The purpose of hiring the lawyer is to take your informal general concepts and put them into legally binding and enforceable agreement. Make sure that you and your fiancé or sweetheart hire separate attorneys. To help ensure an enforceable agreement, both parties need their own lawyers. Many a prenup has been thrown out because an aggrieved spouse did not have legal representation. The attorneys co-write the agreement with their client's best interests in mind. As I stated earlier, the most important ingredient of a solid prenuptial agreement is honesty. Both parties must fully disclose their assets. If it turns out either person has hidden something, a judge can toss out the contract. Also, a prenuptial agreement needs to be fair. In Massachusetts, for a prenuptial agreement to be valid, it must be fair both at the time it was written and also at the time of divorce. This is sometimes referred to as the second look. In other words, you look at it in the beginning to determine if it's fair, and then you look at it again at the time of divorce to determine if it's still fair. Courts do invalidate unfair agreements. If for any reason the agreement was signed under pressure, a party can seek to break the agreement. This requires clear proof of coercion, duress, fraud, or undue influence. As I stated previously, an agreement can be invalidated if there's evidence that false or incomplete financial information was provided at the time of the making of the agreement. To be ironclad, an agreement must be signed well in advance of the wedding. You can't present your honey with a prenup 2 days before the big day and say, "Oh, by the way, I need your signature on this." It's not going to work. The document should be signed as early before the wedding as possible to avoid the appearance of coercion. I believe that a prenuptial agreement should be signed before any wedding arrangements are made, certainly before wedding invitations have been sent out. This allows time for one or the other to back out if they are uncomfortable with the terms. If the discussions reveal such deep and basic differences between two people that they decide not to marry, it's obviously best if all the talks took place well in advance. You certainly don't want to send back those wedding presents, do you? It's really important to follow proper legal procedures. Yes, Lincoln wrote the Gettysburg Address on the back of an envelope, but writing a prenup on the back of an envelope is risky. If you want your prenup to have legal force, it's best to follow the rules by doing things a little more formally. Here are a few more tips. Use only lawyers who are familiar with prenups and the law of the state in which you will be living. Note that you cannot waive rights to child support and payments. Finally, and although it seems obvious, make sure the agreement is in writing and the signing is witnessed and notarized. Bottom line, if you don't want a divorce court to make the final decision about how your assets will be divided, a valid prenuptial agreement can do that for you. However, without a prenup, you're letting your financial future be determined by a third party. Remember that premarital agreements are a personal decision, but without such an agreement, couples relinquish not only power over their assets, but privacy as well. Please consider that there are no certainties in life. None of us have a crystal ball. Do you want your assets to be up for grabs in the event of a divorce? A prenuptial agreement can ensure that each party keeps what he or she has earned prior to the marriage. In conclusion, a valid prenup has to meet the following 4 criteria. Each party to a prenup had to have a separate legal counsel. Second, there was no fraud or coercion in obtaining the agreement. Third, all assets and liabilities were fully disclosed by both parties before the agreement was executed. Fourth, each spouse knowingly and explicitly agreed in writing to waive the right to a judicial, equitable division of assets and all marital rights in the event of a divorce. Until July 2010, the question of whether a postnup is even valid in Massachusetts was a question that hadn't been answered by the courts, or the legislature for that matter. On July 16, 2010, the Massachusetts Supreme Judicial Court issued the first clear ruling that a postnuptial agreement is valid in Massachusetts. The case Anson v. Craven Anson provided a unanimous opinion that postnuptial agreements or marital agreements are permissible and fully enforceable if created properly. The Supreme Judicial Court ruled, however, that postnuptial agreements will be subject to a higher level of scrutiny than prenuptial agreements or separation agreements. The court's decision laid out 5 factors for courts to consider in ruling the validity of postnuptial agreements. First, whether each party had the opportunity for independent counsel. Second, whether there was fraud or coercion in obtaining the consent to the agreement. Third, whether all assets were fully disclosed prior to the execution of the agreement. Fourth, whether each spouse knowingly waived his or her rights to property sharing and support upon divorce. And fifth, whether the terms of the agreement are fair and reasonable. However, what was most striking about this decision is that the court imposed the burden of proof on the party seeking enforcement rather than the party trying to avoid the agreement. This is contrary to the rule that is generally applied to contract enforcement, including prenuptial agreements. Therefore, this rule puts the enforcer of the agreement at a significant disadvantage.